Happy New Year. Daniel Landman, P35797, appearing on behalf of the plaintiff.
And Happy New Year to you.
Happy New Year.
Ma'am, your name?
Jacqueline Ford.
All right. And where are we on this?
Your Honor, this was adjourned over from December 26th.
What first appears to be a quiet courtroom during an ordinary afternoon soon becomes a tense setting filled with financial pressure, legal responsibility, and real human consequences. The matters scheduled today are not about dramatic objections or theatrical courtroom arguments. Instead, they involve actual individuals, unpaid obligations, and judges required to balance compassion with strict enforcement of the law. Landlords appear seeking recovery of thousands of dollars in unpaid rent, while tenants attempt to demonstrate payments that may or may not be properly documented. Each case essentially raises the same legal issue: what occurs when personal promises confront the precise calculations of financial records? Some defendants firmly state that payments were made, yet the financial figures often fail to match those claims. Others present payment proposals that initially seem reasonable until rent balances, added fees, and strict deadlines are examined together. At times, the court appears ready to rule immediately, yet the judge pauses and offers something uncommon in these situations: additional time, but only under clear conditions. In this courtroom, however, time itself carries legal weight and is never granted without obligation. Later in the session, tensions intensify when a personal relationship dispute enters eviction proceedings and the judge establishes a firm boundary regarding control, manipulation, and basic human dignity. Finally, one of the most serious moments arises when issues of health, survival, and housing intersect, forcing the court to confront circumstances that no legal statute can fully anticipate. Remain attentive, because every ruling issued today carries a message, even if each person interprets it differently.
Who was present at that time? This is a commercial property. She indicated she would be able to pay $1,000 to $2,000 before today. My client does not show it on its ledger, so I don't know if any money was paid at all.
I did. I can show it. Yes, I can.
How much did you pay?
I paid $1,400.
14?
Mm-hmm.
Okay.
When was that paid, ma'am?
I think it was paid yesterday.
That's why it wouldn't show up
That's
on the
why you
ledger.
don't show it. Okay. So you paid $1,400, you think, on the 8th.
Mm-hmm.
Okay.
And Your Honor, if we would deduct $1,400 then from the current balance, the balance without cost would be $32,3632. With costs, it would be $34,1132.
Okay. And how are you intending on getting that paid, man?
Well, I work at this commercial property, so I get paid really every day. I had 3 stylists to leave, so I'm just walking down the balance. So in a couple of weeks, I have another 15. Another couple of weeks, I have another 1,500. But yeah.
And the balance isn't exactly being walked down because the rent is $1,758 a month.
$1,758.
Yeah, so the $1,400 didn't even cover January.
Yeah.
Oh, but it's added cost because I'm trying to put one of the units back on the market. So that's why
But
more money. So it's not.
how much are you going to be able to pay them each week if you're saying you're walking this balance down, huh?
Yep, another 1,500 in another couple of weeks, and then another couple of weeks because I want it completely done and down to zero because I'm having
So in 2 weeks, you'll have another 1,500.
Yep.
Not 14, but 15.
Yep, 15, not 14.
And the rent's 17.
$1,758.
So at 18, you're basically coming down about whatever, 1,200. All right. Before I enter a judgment in this thing, I'm going to adjourn it out a week or 2 weeks.
Although this adjournment may initially appear generous, it is actually a calculated judicial strategy. Courts do not postpone proceedings merely as an act of kindness. Instead, such delays often serve to evaluate credibility by requiring the defendant to present verifiable proof of payment before the next hearing date. In effect, the court is shifting the burden of confirmation back onto the defendant. The issue is no longer about verbal assurances, but about demonstrated compliance. Notably, the judge does not reduce the amount owed, waive additional fees, or renegotiate the financial figures. The only accommodation granted is time, and even that opportunity is strictly conditioned. Through this approach, the court is effectively stating, provide evidence rather than assurances. Should that documentation fail to appear at the next hearing, the court's response is likely to become considerably stricter. Moments such as this often distinguish individuals who are capable of correcting their financial situation from those who are merely postponing an unavoidable outcome. The question then arises whether the court's approach in this instance reflects fairness or excessive patience.
That you make that next payment. If you could make that payment the day before so that they know, or bring some receipt saying you made that payment so we can see where you are.
Well, I make the payment online in the app. So should I
Okay,
screenshot it?
so screenshot it. Okay.
Okay.
Can you do that?
Mhm.
Okay. So I'll adjourn this to January 23rd, 2026 at 12 noon. Okay, so try to get that in there before quick as possible, okay?
I will. All right, thank you.
Take care. Real Properties versus Stacy.
Turned over from the 26th. Mr. Hines was present, said he'd be able to pay $700 to $1,000 prior to today. Again, I'm not showing that on the ledger, but if he made a payment yesterday, it wouldn't be appearing.
I made a payment this morning of $852.93. $6.59 of that was a processing fee. So the actual payment was $846.34.
$846.30.
And that gave me a remaining balance due of $1,333.98.
Okay.
Plus cost of $175.
Right.
That's included. That's the
So, sir,
Yes.
how are you gonna get the rest of this paid, or what's your intent?
Same way I paid today. I'm gonna keep working and pay it off, so I'll be able to pay at this rate consistently.
Right, but you gotta work something out with the landlord that they're gonna do that,
Yes.
because you get paid every 2 weeks.
Weekly.
Okay, so you're gonna try to pay 800 every week?
This is what I've made since the last hearing on the 26th.
Okay, so that's about 2 weeks.
Yeah.
Okay, so you would be paying 400 a week or thereabouts?
Yeah, 4 to 5.
4 to 5 a week.
Yes.
Okay. So if I put this over to the 23rd, you should be able to pay another 800
Correct.
to 1,000,
Yes.
right? And how much did you say was owing?
Your Honor, coming into today, not recognizing this payment,
Yeah.
was $2,130.32 plus costs. So with the payment of 846 and change, he's around 1,300
That is, okay.
plus cost.
So,
If you can pay the 500 a week, the balance will be pretty small.
it'd be pretty small, and then we can try to figure out how to. So, sir, I'm gonna put this out to the 23rd, 2026. Okay?
Okay.
Get those payments in and try to, you pay it through the portal? Do they take it through the portal
Yeah.
for you? Okay. Make sure you have screenshots that you made those payments. Okay?
Yeah.
And then what the balance is. And then we'll see where we are and where we can head with it.
Thank you, Your Honor.
You're welcome. Westridge Mobile Home Park versus Jessica Holloway. And Billy Hubbard.
Hello.
Hello.
Your Honor, Mr. Hubbard was present on the 26th of December.
Yes.
He claimed he was going to be having an appointment with Hawk on this past Tuesday.
Yes,
Did you?
yes, I did. My wife spoke to him. I was told that they could help, but they wanted to see what happened with my SER first.
Okay, and you don't have an answer from that?
Yeah, I had to return from Hawk.
No, from,
The SER, I had to, I called in yesterday to make sure everything was on schedule for today. And they told me that something was filled out wrong, so I had to sent it in last night. It's already been sent in to last night, so they should be getting back with me today.
okay, what do you
I
have?
do have the tracking number for it too.
You do?
Yeah, it's in my.
Okay, okay. What do you have as this balance?
Your Honor, rent to retain is $1,677.62. Costs are $236 for a grand total of $1,913.62. The tenants have had one adjournment if the SER has been applied for and the DC 539 has been filed.
Yes.
They would be entitled to another adjournment.
Adjournment, correct. And you just haven't, did Hawk say they were trying to wait on the SER?
Yeah. Yes.
In this situation, the court functions as more than a body that simply enforces legal rules. It also serves as a critical checkpoint in the process. Assistance initiatives such as STR programs and rental aid are not technical loopholes within the system. They exist as essential resources for individuals facing housing instability. However, these programs only operate effectively when documentation is accurate and submission deadlines are properly observed. A single incorrect form or missed filing can halt the entire process. The judge's recommendation that the tenant retain the available funds carries a subtle but significant message. The court recognizes that financial pressure often leads individuals to spend money that was originally intended for rent obligations. By clearly instructing the defendant not to spend those funds, the judge preserves the possibility that the matter can still be resolved. This approach represents patience, but patience accompanied by defined limits. The court is willing to provide assistance, yet it does not do so without caution or oversight. This raises an important question. Do housing assistance programs genuinely prevent eviction in the long term, or do they primarily postpone the final outcome?
You had to resubmit on the SER.
Yeah.
You know what, I'm gonna put this one out to the 23rd also. His balance is at least within the range that they would pay irrespective of what the SER does. So 23rd, 2026 at 12 noon. Okay. And it hopefully will have a clearer answer.
I'll also have cash by then as well. My check comes Friday, so I'll be able to put cash towards it as well.
Okay. Do me this favor. Well, you have that cash. Hold it, don't spend it.
Oh, of course, yeah. No, that's what it's for. Yeah, no.
But hold it, don't spend it. Let's see what they'll pay and see if we can get you ahead.
Okay,
You follow me?
right. Okay, thank you.
All right.
All right, appreciate you. Have a nice day.
Tolbert was present on the 26th. He indicated he was temporarily off work.
You're right.
He was hoping to be able to pay by the third week of January. He was encouraged to apply for rental assistance. I don't know if in fact he did so though.
Did you do that, sir?
I have yet to do so. The owner of the house, I was waiting for her to pay for the rent. She has it.
She what?
The owner of the house has the rent money. She hasn't paid for it yet.
She hasn't paid for it. What do you mean?
The owner of the house has not paid for the rent yet. It doesn't belong to me. And so therefore I did not ask for rental assistance.
Okay, you lost me there. So, because this is a trail. I'm sorry,
Yes.
right? So the owner hasn't done what?
Well, the owner of the house has the money to pay for it, and she has not paid for it yet.
Okay, let me ask you this. Did you give the owner money?
I didn't give her money, no.
But she's the one that should be paying this? Is that what you're saying?
Yes.
Okay,
Your Honor, my client's lease is with Mr. Tolbert and
right.
payments, we're showing, I've got a ledger with payments going back as far as at least May, if not further. So I guess, I think I don't get where he would be relieved of the obligation to pay. There might be somebody else who has offered to make payments on his behalf, but I'm not familiar with any agreement.
Who paid your rent before now?
Well, it belonged to Carol and I, but she passed away. But when she passed away, I had reason to believe that she gave it to her family, and her family was supposed to pay for it. I offered to pay for it, but she did not. She did not give her approval for me to pay, so therefore I did not. I have yet to make payments for it, but I received a check on the 16th of this month, and I have every intentions of paying for it.
Okay, so the check, let me ask you this. Will the check that you receive on that date, will that cover everything?
Well, I'll receive a check for approximately $400 and some, and I can put towards the debit that we owe.
Okay.
Or I can,
What's the current balance?
1467.25, Your Honor, plus costs of 183 for a total of 1650.25. And just so the record is clear, sir, you are living there, right?
yes.
Okay.
This moment illustrates a classic misunderstanding of legal responsibility within housing agreements. The defendant appears to believe that another individual should be responsible for the required payment, yet the lease agreement clearly assigns that obligation elsewhere. In a courtroom setting, personal belief cannot override the terms of a written contract. The judge therefore clarifies the issue directly. If an individual occupies the property, that person remains legally responsible under the lease conditions. At the same time, a broader issue becomes visible. The court acknowledges that confusion may exist among the parties, but it refuses to allow uncertainty to function as a legal excuse. When the judge states that there is no tribal issue here, the statement effectively closes the door on attempts to complicate what is legally a straightforward contractual matter. Situations like this often mark the final stage of eviction proceedings. Once the court grants possession to the landlord, the timeline for removal becomes strict and difficult to reverse. The central question then becomes where the responsibility truly lies, with the tenant, the family members involved, or perhaps with all parties collectively.
So you're going to have to get this paid because there's no tribal issue in this. I'm going to grant a judgment for possession to the plaintiff. No tribal issue after hearing for the 1650.25 total. And sir, whoever it is that you think is supposed to be paying it, and then between that person and yourself, you guys are going to have to pay this. I will extend his writ date from the 20th to the 23rd. So you're going to have 2 weeks to get that done. Okay?
I greatly appreciate it. Thank you.
All right. Thank you.
Officer. Thank you, Your Honor.
Thank you.
Yeah.
You do the same, sir.
Thank you.
Good afternoon, Your Honor. Andrew Cates, P7829, representing Mr. Berry, who stands to my left. Mr. Berry, please introduce yourself.
All right. Your name?
Good morning. Good afternoon, Serenity Sperry.
All right. Where are we on this case?
Your Honor, this is the termination of tenants case. There's 30 days notice to quit issued to the defendant. We have not come to any sort of a resolution, so we are asking for this matter.
Ma'am, what's your position now?
You said what?
What's your position on moving?
Like, where am I at?
Yeah, or do you think that you should have to?
So I wrote something out because I have something that I want to say, but I just don't know how to say it unless I'm reading it because I have post on.
Okay, go ahead.
Okay, it'll just take me a short minute. So I couldn't retain a lawyer since the last court date. So I wrote down what I want to say. All I want to say is that we have been together the last roughly 10 days, every single night and almost every day. We've been on great terms. We haven't fought unless the dogs are putting my stuff in storage or court was mentioned. I've had my stepfather at my house taking care of my dogs while I've been with him at his mom's house because he didn't want to come to our house still because he says he wants some of the dogs gone, which he offered to pay rent for a whole separate house for the dogs and my family. And he says that the thought of me having my male friends over when we weren't on good terms disgusts him. He also wants his.
Objection, Your Honor.
To what?
Is there a legal point to this? I mean, airing out her dirty laundry in open court isn't exactly.
I think your client brought the dirty laundry here. Go ahead, ma'am.
So he said that disgusts him. He also says he wants to set up his cameras and security alarms and have the house completely emptied. And then he wants the house emptied and my stuff in storage, but then he wants me to still live there, which I explained is not a comfortable situation if I can't have my clothes and my stuff in my bedroom. If we're together and I live there, but he can just kick me out and lock the doors whenever he wants. That's the only time we start arguing is when that conversation is brought up. But I've been with him at his mom's house because of what I just explained. We've discussed plans and solutions constantly to get through this together, but we disagree on the time frame. He wants me out within 30 days, but I told him that I could start remodeling my grandma's house where I could live and take my dogs and all my stuff to in March, and it could be completed by April, which is roughly 90 days. He has money invested in the house and he wants his money back, so he doesn't want to wait the extra 2 months. However, I need this extra 2 months so I can get my house together, move my dogs and my stuff in my house, and then we can work on us. But we'll only have somewhere, we'll each have somewhere to go in the future. And if I could get a couple more months and get my house remodeled and move all my belongings there, it would save us from all the arguing that we do and we would be healthy and happy. Tom has helped me every day the last 10 days we've been together. Every day we've been taking care of things. Everything's been lining up and I've been getting priorities done each day. If we can continue to do good and not argue about court, and if I had a few more months to finish doing what I need to do for myself and for my future, then everything would work out really great. Also, my mom is in this jail and is supposed to be going to rehab. All her belongings, her stuff is scattered all around the house. So I've just been praying that she'll be home before the end of the eviction process so she can get her belongings and pack her own stuff up so I'm not stuck doing it by myself. She's been there the whole time I've been there. Tom told me today that he would be okay letting you know that he was okay with 30 days. But if I'm being realistic and truthful, I really need 90 days. I could be back at my grandma's house, comfortable, safe, and happy. It would fix a lot of mental illnesses that I've been suffering with the last year. I just want to be back home. I want to feel secure. In 90 days, that could be done, but I need to wait till it gets warmer to start remodeling my house. I still offer to try to pay him, but he doesn't want to take my money because he just wants that. That's all I have to say.
How did you end up in this house? Because, I mean, what's contained on the complaint, I think is false.
I ended up
From
in
what?
the house.
Yeah.
He gave me the keys and I moved all my stuff into the house. My mom was there, my brother was there. He gave them keys. We all walked around. We looked at all the work that needed to be done. Got right feeding. You know, I had all the puppies. It was 13. They were very young. So I set up everything for the puppies.
So I want to, you can stop there. Counsel, on this complaint, it's alleged that defendant is a trespasser and has no right to be there. I don't even know how he gets to that, if that's the circumstances.
Your Honor, I addressed this at the last hearing. You know, I understand trespasser as a term of art for a legal mind. However, he has asked her to leave, so to him, she is.
On a landlord-tenant summary proceeding, that is not a trespass.
I understand.
Under
that,
any definition, that's not a trespass.
I understand that, Your Honor. My client is brought me onto this case. He had already filed that. You know, the thing is the issue isn't proving a trespass. The issue at hand in this court is that there is a piece of property owned by my client. He has requested it back and he wants possession.
Where he's residing.
He is not residing in the property, Your Honor.
where they were supposed to reside.
That was the.
So here's my problem, counsel. My problem is, and this was the problem the first time around, is that he somehow or another goes into this place with this young lady. My understanding is, at least from what was said, don't know, was that it was bought for her. That's one of her allegations that she has regarding her client. That at some point then, and there's family of hers that's moving into the house. Then at some point he gets sick and tired of her, doesn't like her, doesn't like what she's doing, and she remains constantly under the threat of being evicted. And I think it's correct that what she wants to do is she just wants to have herself, and I think probably the most operative words that she said was where she can be safe and secure. And that's what she's trying to do. Because quite frankly, as I see this, I think your client misled this young lady as to her status vis-a-vis him and vis-a-vis this house. And I'm not going to have a piece in a sort of this almost legal fiction that you can invite these young ladies into your house, be there, and then when you decide you're tired or done with them, just boot them into the street. That's not going to happen. It's not going to happen on my watch.
This represents one of the most striking developments within the entire court session. The judge is not merely deciding a dispute regarding property possession. He is addressing what appears to be a broader pattern of personal control. By identifying what he describes as a legal fiction, the court establishes a clear ethical boundary. A person cannot invite another individual into a residence, create uncertainty regarding security or tenancy, and later attempt to use the legal system as a tool to remove that person when circumstances become inconvenient. Such direct judicial reasoning is relatively uncommon. In this instance, the judge places emphasis on personal safety, stability, and dignity rather than relying solely on technical legal loopholes. By refusing to grant possession under these conditions, the court sends a clear message that imbalances of power will not automatically be validated simply because certain documents exist. This situation raises an important question. Should eviction courts take emotional and relational circumstances into account, or should they limit their focus strictly to contractual and transactional matters?
So what I think, no, you know what? You can say what you want to say, but you probably don't want to say it to me. So I think what you ought to do, you ought to go out there, talk like civilized human beings, talk to this young lady like she has some value and worth in life. Let her get to the point where she can be safe. That's only going to take a couple of months. Let her do that. She has a plan in mind, and quit like leading her one way, then the other, and then just getting to this court and trying to kick her out, because that's not happening, and certainly not happening, not today. So I'm going to pass this matter. You guys go out there, talk about it, see if you can come to a point at which she'll move out. She says she'll move out. It's just she needs time to do it in an orderly fashion. Pass this case.
Have a good day.
All right, you need to talk to them, and then I'm going to call your case back up.
Okay. Oh, okay.
Don't forget your notepad.
Thanks.
Blue Heron Point versus Roderick Casey. Hello, ma'am.
Hello,
Your name?
Sharon Lee.
All right, and you're Mr. Casey's mother.
Correct.
All right. And where are we on this case?
My son had a procedure yesterday, and today he had a follow-up. So that is why he's not here today.
Okay.
And the doctor advised him not to be out and not to make decisions. So today I am here on behalf of him to see if we can get an adjournment.
All right. How much is owing on this?
Your Honor, if I may.
Yes.
Thank you, Judge. I am showing a balance due of $11,168.59. That is inclusive of $10,998.59 in rent to retain and $170 in attorney fees and costs.
Okay.
And so although I do appreciate, the nature of the situation, Your Honor, this is the third hearing. This is another adjournment that has been requested. There's been no answer, no attorney on behalf, no affirmative defenses, no motions, no rental payments made since September of 2025. Obviously, no contact with my client. We did attempt to make contact. I do understand that the defendant is potentially in the hospital and is suffering from some medical ailments. However, we can't keep this case open without proper procedure. So we would be seeking.
If you say I'm not following proper procedure, I think you better back that down, counsel. I mean, my understanding is he had a lung transplant. Mom came in. I adjourned it out so that they thought a certain course would happen and to even be able to try to deal with it. So I understand why we're here and why it's at this particular point. Ma'am, how is there going to be any payment on this?
I'm not sure. I can't speak on him, for him. I know he'll be able to come out in about 2 weeks. That's why I'm asking for an adjournment.
Okay, let me ask you this though. If he comes out in 2 weeks, he's not going to have the funds to get this paid, right?
I know he can pay something on it. I know that, and he can make arrangements.
Okay, let me ask you this. Given everything that he's just recently gone through, what's his long-term plan? Is it to try to remain in these premises? Is it to try to move somewhere else where certain care can come to him or anything else along those lines? Do you know? I mean,
I don't know. He may have to move.
gotcha. Okay. That's something tells me ultimately that's what's going to probably transpire.
It
Because I don't
probably
think
will.
he's going to have these funds. This balance isn't going to be getting any higher. And so I'm inclined to adjourn it out 2 weeks. He needs to make a decision. I want you to understand, ma'am, and you can explain this to him, that on the 23rd, unless he has these funds, and I realize you also don't know what funds he has. So somehow you're going to have to get that answer. So it's going to be what funds he has and really if he's going to move, which I think is ultimately what's going to end up happening. Okay. So I'm going to adjourn it to the 23rd. I need an answer to that. Ideally, irrespective of the answer, I'm probably going to grant them a judgment for him to either pay that amount or to move out.
Okay.
Okay?
All right.
So that we're all clear on that.
Your Honor, if
That's
I may.
great.
Yes.
I have a question if, for the defendant's mother, if she's had an opportunity to speak to legal aid on behalf of her son, they could potentially offer some type of services considering the situation. I'm not sure if this court offers legal aid in the court.
No, we do. And I think, I don't know that legal aid would necessarily speak directly with her without getting some permission from him, which is part of the difficulty at the beginning. She came in and was just, quite frankly, she was doing what a mom does. And she's just trying to.
Ma'am, my son could not speak to anyone. He was on a ventilator.
He was on a
He had a double lung transplant.
Right. So what it is if there's in the interim, and let's put it this way. Coming out of the hospital there should be social workers and others that will be talking to your son about sort of his care afterwards, which will give him a clearer picture.
Yes,
right?
He has nurses, he has social workers now.
that are doing that and probably will frankly be more advantageous as to where he has to go than would legal services at this point. Okay.
Okay,
So he needs to talk to them about like housing and those kinds of things in his care. Okay. So I'm
Okay.
giving this 2 weeks. And I know it's a lot within those 2 weeks, but it sounds like he's at least in a, oh, Miss Amy.
I'm sorry.
No.
I'm happy to give you guys minutes right now.
Okay. So we have somebody from my court liaison officer that can get in touch with what services might be available for Mr. Casey.
that's great.
Okay? So 23rd at 1 p.m.
One, okay,
Okay? And so just so that you understand, in some form or another, it's likely next week that in the next 2 weeks, I'm going to grant a judgment or something. All right?
I understand. And I appreciate you so much for being patient in the apartment. Well, thank you for your patience. It's been a rough go.
The proceedings observed today demonstrate the wide range of discretion that courts may exercise when handling housing disputes. Across several cases, the judge balanced strict legal duties with the realities faced by the individuals appearing before the court. Additional time was granted where genuine effort appeared to exist. Firm decisions were issued where responsibility was denied, and the court refused to allow legal procedures to become instruments of manipulation. Some rulings depended on payment plans supported by proof of compliance, while others involved assistance programs that temporarily delayed eviction. In certain cases, however, possession orders were issued once the available explanations were no longer sufficient. Each decision carried consequences extending far beyond the courtroom itself. These matters were not solely about financial debt or property rights. They were also about credibility, personal accountability, and whether individuals fulfill obligations once an opportunity has been provided. In perhaps the most significant moment of the session, the court reminded everyone present that safety and stability remain important considerations, and the legal system is not entirely indifferent when clear abuses of power occur. If you found this courtroom session as compelling as we did, consider leaving a like, sharing your opinion in the comments, and subscribing for more detailed analyses of significant courtroom proceedings.